Thank you, everybody who's joining online, and the five of us here in person. So today's presentation is on empaneling juries and discharging jurors. I'm going to be concentrating on three criminal code sections. The first is the consent excuse provision under section 632. The second is the challenge for cause under 638. And the third is the discharge provisions under 644. Jury selection is obviously much broader than that. It has constitutional dimensions. There are two charter rights directly on point, 11F and 11D. Legislatively, there are criminal code provisions that govern essentially what happens in the courtroom, and then territorial legislation and regulations regarding how you assemble the jury panel. I'm not going to be giving a kind of comprehensive overview of the entire jury selection process. I did, in the course of researching this, come across a very good article that did give that kind of overview, if you are interested in looking that up. The other thing that's kind of alluded to in that article is that there were very significant changes made to the jury selection process by Bill C-75, which came into force in September of 2019. This doesn't mean that anything you find that predates 2019 is, just sort of completely useless or overtaken. But I would urge caution if you are citing sources pre-2019. You want to think through whether what you find in that case law would be impacted by the changes in 2019. So as I said, we'll start with the consent excuse provisions in section 632. I'll go over the legislation and just kind of a general overview of how this typically works in the jurisdiction, and their scope and the relationship to the challenge for cause procedure, which is actually arguably the subject of a bit of controversy right now. So this is section 632. And there are a few phrases here that we're concentrating on. One is personal interest. The other is a relationship to various actors in the trial process. And then there's a more general personal hardship or any other reasonable cause, all of which could lead to a person who's been summoned for jury duty being excused. This is intended to be a kind of a pre-screening process for what the case law refers to as obvious partiality and hardship. The cases should be, or the issue should be obvious enough that the consent of counsel is just sort of presumed. And if issues, in particular issues of partiality, are not obvious, and the consent of counsel cannot be presumed, then those types of issues ought to be dealt with under the challenge for cause process. As I mentioned, there is arguably a kind of emerging split in the case law about how broad section 632 can be. In terms of procedure, and I'm speaking really just obviously from local experience, but if you've been to jury selection, this is sort of one of the first things that happens is that the trial judge will provide a brief overview of the role of the jury and the charge before the court. The people who've been summoned are going to be introduced to the judge, the lawyers, the accused, and the Crown will be invited to list the names of any witnesses. And then the trial judge will invite anybody, either who has a relationship to any of those individuals or who has some kind of hardship or other reason why they're seeking to be excused, to come forward. There's usually a microphone set up in the room, and people will come up, explain to the trial judge what their issue is, and you'll get like a pretty quick ruling, just kind of a thumbs up or down from the trial judge. As I said, there is a bit of debate about the scope of this. There's an Ontario Court of Appeal decision called Kovach. This was a case about intimate partner violence. The local practice there apparently is that prospective jurors are given a questionnaire that they fill out at the beginning of the process. In that case, one of the questions asked about people's past experiences with intimate partner violence. And it seemed to be really targeting individuals for whom sitting through a trial, the subject matter of which was intimate partner violence, would be sort of traumatic or impose a hardship. One juror did confirm that they had experience with intimate partner violence, both personally as well as family members. And at the 632 stage, the defense asked the judge to make some inquiries of that juror about their potential partiality. The trial judge declined and found that the only purpose for those questions was to explore the hardship issue, and that she wouldn't therefore question the juror at all about whether her experiences would tend to make her more or less impartial. The Court of Appeal dismissed the appeal essentially because there was no prejudice. But they did comment that the trial judge's interpretation of 632 was unduly narrow, and that it can be used as a tool for screening manifest and obvious partiality. But again, given that there was no prejudice in that case, the appeal was dismissed. The Saskatchewan Court of Appeal essentially came to the opposite conclusion. In that case, the accused ended up being convicted of murder arising out of methamphetamine trafficking. The accused himself was Caucasian, but his co-accused were Indigenous and were alleged to be members of a street gang. He submitted that the trial judge should have incorporated questions about racial bias into the Section 632 consent excuse process. The Court of Appeal really strongly disagreed with this and emphasized the distinction between 632 and the challenge for cause process. And their concern was that 632 could be used as kind of a backdoor to avoid some of the rules and limitations in 638. And in particular, as we're about to see, before you can start questioning jurors for partiality on the challenge for cause procedure, there is a kind of preliminary threshold that you're going to have to meet. And the Saskatchewan Court of Appeal was concerned about using 632 as a kind of end run around that first hurdle. And this, just a quote from the Saskatchewan Court of Appeal, that it's presumed that jurors will carry out their duty without bias or partiality, and the questioning of jurors in open court regarding their personal beliefs and biases is only permitted when that presumption is rebutted. And we'll see how that's done under the challenge for cause procedure. So again, we'll look at the legislation, some of the key features, what the court means when it talks about bias and prejudice, what that threshold is for engaging the challenge for cause process, the process itself. And again, I'll give you a couple examples from the case law. I will say that of the three topics today, this is the one that I have the least personal experience with, which is to say none. Section 638, the key term here for our purposes today is that a challenge for cause can issue where a juror is not impartial. Section 640 gives a brief outline of the procedure to follow. This is, as I mentioned about Bill C-75 in 2019, this is really the epicenter of the changes that were made in Bill C-75. Broadly speaking, there were two very important changes to know about. One is transitioning from a system where the challenges were decided by two jurors who were impaneled as triers. Now under the new procedure under 640 sub 1, it is the judge who decides. And the second thing is that peremptory challenges were eliminated. And there's some case law to suggest that the elimination of the peremptory challenges means you have to give a broader interpretation to the challenge for cause. So again, the two things to keep in mind here, this is something that's determined by the judge, and there is discretion on the judge to exclude all of the other jurors when deciding on a challenge for cause. So the key features of this is that the challenge has to be authorized ahead of time by the trial judge. It can proceed where the threshold is a reasonable possibility or realistic potential of bias or irrelevant prejudice in the community that could taint the impartiality of jurors. You want to agree to the questions in the procedure in advance. Although the legislation says that the rest of the jurors may be excluded, the case law basically says that they ought to be. And then it's now the trial judge who determines if the challenge is true, which is to say whether the juror will be able to act impartially. The key decision on this is Chuan, which was a case that focused on whether the removal of peremptory challenges violated Section 11 of the Charter. And insofar as it did not, whether those changes could apply retrospectively to people whose charges arose before 2019, but whose trials were happening after 2019. And actually, I believe the Chewin trial began on September 9th, 2019. So it was literally like the day of the coming into force. Unfortunately, in Chewin, the court really fractured quite badly. There are 5 different sets of reasons, and the different reasons disagreed on a number of different points. Generally speaking, from what I've seen, since Chewin, lower courts have largely followed the reasons of Justices Moldaver and Brown. Although I will say that the other thing that they seem to try and do is kind of paper over some of the differences to establish that what they're doing in a given case is also consistent with what some of the other judges had to say. So as I said, we're looking at this stage for bias and prejudice. The court has defined 4 different types of prejudice. Interest prejudice arises where a juror has a direct stake in the trial. A specific prejudice can arise when you have an opinion about the particular allegations before the court. This is usually where pretrial publicity comes into play. A generic bias is really what's been the focus of a lot of the litigation in the past 20 years about challenges for cause. And that's where a juror holds stereotypical attitudes about a defendant, victims, or witnesses, or even the nature of the crime itself. Conformity prejudice is actually, it's a really interesting one that I think is kind of understated, but it's essentially where the case is of significant interest to the community, and that causes a juror to perceive that there's a strong community feeling and expectation around the outcome. And you can imagine a juror on a really notorious case, and you can kind of imagine that conformity prejudice and sort of the pressure to essentially to convict and not to be one of the 12 people who's responsible for releasing someone who's accused of something really heinous. There is a 2-part inquiry when you're looking at these biases. The first is what's called attitudinal, and that is your subjective belief. So if you have a subjective bias about people of a certain race or from a certain community. And the second, which is really the focus of the inquiry, is the behavioral part of it, which is not simply what do you believe, but it's are you able to set aside those biases when judging the case? And you have to analyze this in the context of what they call the other cleansing effects of the trial process. And that includes the oath that the juror takes. It includes the presumption of innocence, the rules of evidence, the solemnity of the proceedings. And a lot of faith is put in this trial process to empower jurors to set aside biases that they may subjectively hold. So as I said, the threshold is a reasonable possibility or realistic potential. It's not intended to be a heavy burden for the challenging party. And in fact, since Chewin, there's at least one case that suggests that evidence may not be necessary at all. So you can see the wording from Chewin that's been seized on is challenges for cause must be available wherever the experience of the trial judge in consultation with counsel dictates that in the case before them, a realistic potential for partiality arises. And in a subsequent case that we'll be looking at called Veltman, that was interpreted as meaning that formal evidence is no longer an integral element of a challenge for cause application. And that while there's no need for formal evidence, there must be a logical or common sense basis for the inquiry. I would say that that's relatively safe to apply if you're talking about sort of notorious, in particular, racial or gender stereotypes and biases. But if you're getting into something a little bit more idiosyncratic, then I think that need for evidence is going to creep back in again. One of the other points from the case law is that the basis for a challenge for cause doesn't have to be like a listed or analogous ground in section 15. And there are a couple cases we'll see that stand for the proposition that these also aren't limited to like immutable characteristics like race or gender or sexual orientation, or religion. So in terms of the process, it's traditionally been described as kind of a mini trial where prior to 2019, there would be two jurors acting as triers. Since 2019, the trial judge is now the trier. Under Chewin, the Supreme Court of Canada has also said that given that the trial judge is the trier, it's appropriate for the trial judge to put the questions to the juror after consulting with the parties about how they should be phrased. The challenge for cause process prior to the 2019 amendments often contemplated counsel putting these questions to potential jurors. And as I mentioned earlier, under Chewin, again, the Supreme Court has said that as a rule, the rest of the jury panel should typically be excluded for this exercise. One of the really interesting things that is, I would suggest, still being worked out is what the content of the question, in particular when you're talking about biases and prejudices, should look like. The case law will refer to the Parks formulation or the Parks question. Parks is a decision by Justice Doherty from the Court of Appeal for Ontario. And the Parks question was, would your ability to judge the evidence in the case without bias, prejudice, or partiality be affected by the fact the person charged is a Black Jamaican immigrant and the deceased is a white man? This is one of the things that the court divided on in Chewin. Everybody agreed that Parks was not intended to be like a kind of fixed formula, even to the extent that like a WD instruction is. But they do urge caution about going beyond it. And they stress the need to protect the privacy of potential jurors as much as possible. There's a real fear in the case law on this about kind of sliding into what they always refer to as a US style inquiry, where there's kind of a full formal voir dire and potential jurors can be questioned extensively about their lives, essentially. Justice Abella called for what she termed more probing questions that have traditionally been asked to properly screen for subconscious stereotypes and assumptions. And there were a couple of judges, Martin in particular, but arguably also Justice Rowe, who basically just said, like, this is not the time to determine this. So the threshold for actually determining the challenge. So this is if you've engaged the threshold for like a reasonable possibility or realistic potential, you've now asked the questions. The threshold that the judge now has to apply is simply the question of whether the juror will be able to act impartially. This is something that is determined on a balance of probabilities. And in Find and other cases, it's an analysis that starts with a strong presumption of juror impartiality that has to be displaced. As I mentioned, under the old regime, this was done by jurors. And so one of the really interesting sources you can turn to for guidance on this, again, being somewhat cautious about it, but if you look at the old jury instructions that were given to the triers, this is how they read. So the judge would say to the triers, your job is to listen to the answers each person gives. You decide based on those answers whether the person is acceptable or not acceptable as a juror in this case. An acceptable juror is a person who would likely approach jury duty with an open mind and decide the case on the evidence given at trial and the legal instructions given by the trial judge. If you are satisfied that the person would likely approach jury duty with an open mind and decide the case on the evidence given at trial and the instructions of the trial judge, you should find that person acceptable. If you are not satisfied that the person would likely approach jury duty with an open mind and decide the case on the evidence given at trial and the instructions of the trial judge, you should find that person not acceptable. One of the things that'll be interesting to see as the case law develops is, and I haven't been able to find it for this presentation, but like litigating a trial judge's reasons for either impaneling a juror or excluding them. on the basis of their answers to these questions, and how that case law develops and what kind of reasons are required. Because one of the virtues of the trier system is that no reasons were given, and you got a very quick thumbs up and thumbs down. And I suspect appellate courts are going to want to be able to preserve that kind of quick, efficient process without imposing too much on judges in the way of giving reasons. But it's something that I haven't really seen hashed out at an appellate level yet. So as a few examples of these kinds of challenges, I mentioned Veltman earlier. It's actually a very interesting case because it sort of goes crosswise of what you typically expect these mechanisms to protect against. Mr. Veltman was accused of murder and attempted murder motivated by Islamophobia. And everyone was aware that the Crown, among other things, would be leading evidence of this white nationalist manifesto that had been authored by the accused. The case also received significant publicity. This occurred in London, Ontario. So you might recall it. It was kind of the mid-2010s. So the questions that were raised ahead of jury selection were hardship in hearing the evidence, biases that jurors might hold against white supremacists, biases that they might hold against white Christian men, and pretrial publicity. Essentially, all four of these were canvassed, but the second and third were sort of collapsed into one. So there wasn't like an explicit question asking people if they had biases against white Christians, unsurprisingly. So these are, sorry.
Can I just ask a question on that? You say hardship in hearing the evidence. Do you mean hardship in being able to listen?
No, not your physical ability to hear, but like it was also like this was a case where he, I think he ran over a family with his vehicle, and like emotional hardship, psychological trauma from being exposed to the evidence is what they're targeting here.
That's interesting.
So this is the formulation that the trial judge came up with. I will note that Veltman is being appealed, but from what I've been able to see, the jury selection process is not part of the appeal. The appeal focuses on some issues of admissibility of certain types of evidence. So this is what the trial judge came up with. These are the questions that were, I'll say also, this is always prefaced with a sort of explanation of what impartiality is and the importance of partiality. So there's a sort of preamble to these questions. And then the jurors are asked, have you seen, read, or heard anything about this case in print media, broadcast media, social media, email communications, or any other source of information? Are you aware of any comments made by public figures about this case? Have you attended any vigils, marches, or other events relating to this case? Have you received information about this case? Or sorry, if you have received information about this case, and then they repeated the different sources. Would you be able to set aside such information and decide this case impartially based solely on the evidence and the instructions of the trial judge? If you have formed any opinions about this case, including opinions about the guilt or innocence of the accused, would you be able to set those opinions aside and decide this case impartially based solely on the evidence and the instructions of the trial judge? Would your ability to decide this case impartially based solely on the evidence and instructions of the trial judge be affected by the fact that the accused is a white Christian man accused of having extremist right-wing views associated with white supremacy? And then with the same preamble, would your ability to decide be affected by the fact that the accused is accused of violent crimes, including crimes of terrorism against persons of Pakistani descent of the Muslim community? There's a different formulation, and it's a subtle difference, but I'd suggest it's really important in a case called Glasgow. And in that case, they split off the two questions that were sort of put to jurors as a compound question. So the first question is a juror is asked to answer yes or no to the question, do you have any biased beliefs or preconceived notions about Black men being more prone to gun violence? And the second, if they say yes, is would you be able to set aside those beliefs and decide the case based solely on the evidence at trial and the instructions of the trial judge? There's a similar example of that in a case called Martin. This was also recently litigated again in a case called Kalu, where the accused is described as a Black man of Jamaican descent. The defense proposed like this very long multiple choice format that required jurors to choose between strongly agree, disagree, or strongly disagree, or don't know in response to questions about attitudes. The trial judge disagreed with this approach, said that it was too complex and too kind of invasive of the juror's privacy. And so the trial judge used the kind of compound question from the development decision where it's not number one, do you hold these beliefs? Yes or no. Number two, okay, if you do, can you set them aside? But it's just a compound question that says, insofar as you may hold these beliefs, would you be able to set them aside? Yes or no. So you don't require the juror in a public forum to put their hand up and say, yes, I hold a racist belief. The court commented in Kalu that the challenge for cause procedure allows the exclusion of those persons who cannot be impartial. The issue is not whether potential jurors hold certain beliefs, but rather whether they are able to set aside their beliefs and decide the case based solely on the evidence at trial and my instructions. And the multiple choice format of the challenge questions suggested by the applicant, who is the accused, is not appropriate. It is intrusive to a juror's privacy. It requires them to articulate any opinions they may espouse, and the questions may be confusing. So again, the focus is on the behavioral and not the attitudinal. In Chuan, they comment that the purpose of this is not to out people as racists. It is to get directly to the point, which is that insofar as you may hold these beliefs, can you set them aside? The next two cases are about the threshold for undertaking this inquiry, and they really underline the relatively low threshold that you have to meet in order to bring a challenge for cause of this kind. So in that case, the accused was charged with murder. He admitted causing the death, but claimed that he was acting in self-defense. There were addictions issues regarding the victim, the accused, and several witnesses. The accused sought to challenge for cause on the basis of biases towards people who live with addiction. The trial judge dismissed that application, finding, first of all, that drug use is not an immutable characteristic and therefore not a proper subject for a challenge. And secondly, that the evidence relied on by the defense was not sufficient to establish widespread bias or antipathy against drug users. That evidence consisted mostly of local media reports, and they actually provided excerpts from the comment sections and subreddits regarding, this was in Edmonton, regarding drug use in Edmonton and some of the problems that occasions. The appeal from conviction was allowed. The Court of Appeal stated quite explicitly that you don't actually need an immutable characteristic in order to engage this process. They found that the trial judge had erred by narrowing the focus of the analysis to drug use as opposed to drug addiction. That the evidence that was being proposed should have been given some weight. Again, keeping in mind that the really low threshold that we're targeting here, which is this realistic possibility threshold. I would be careful about giving too broad a reading to the Court of Appeal decision, because they do make this comment that a trial judge approaching the application to challenge for cause properly could conceivably determine, as the trial judge did here, that concerns over potential partiality could be sufficiently addressed through proper instruction. So I wouldn't read Sullivan for the sort of conclusive proposition that a challenge for cause regarding drug addiction should be allowed. It's that the trial judge in this case didn't apply the proper test, and they do leave open the possibility that a trial judge applying the correct principles could nonetheless arrive at the conclusion that a challenge for cause was not warranted, because any preconceived notions that jurors have about drug addiction may have been properly addressed through appropriate jury instructions. Unfortunately, in this case, those jury instructions weren't given, and so the appeal was allowed. Similar issue arose in Whitehawk. This was an Indigenous accused in Saskatchewan who was a member of a street gang called the Indian Mafia. He was permitted to engage the challenge for cause process on the basis of his racial identity, but not on the basis of gang association. And again, the Court of Appeal allowed the appeal and ordered a new trial. The Supreme Court of Canada decision in Find that I mentioned earlier, one of the things that it stands for is the proposition that it's very hard to meet the challenge for cause threshold purely on the basis of the alleged offense. Find was a case of sexual interference and sexual exploitation offenses against children. And basically what Find tried to argue is that he should be allowed to screen the jurors for biases and their ability to be impartial when addressing allegations of sexual abuse of children. And the Supreme Court of Canada flatly rejected that. The Court of Appeal here distinguishes the offense-based bias, even though it's about being part of a street crime. And I believe there were actually criminal charges on the indictment. But they state that in this case, the bias relating to the characteristics or circumstances of Mr. Whitehawk were prejudicial in a very direct way. That is, because he was a member of a street gang, he would be more likely to be found to have committed the murders. So again, obviously membership in a street gang is not like either a listed or analogous ground. It's section 15. It's not an immutable characteristic. But those aren't the questions to be focusing on. The question is whether it could undermine juror impartiality. Okay, so that brings us to discharging of jurors. And again, we'll go through a bit of the legislation. You're dealing with a very new and a very different threshold regarding the discharge of jurors. I'll go through a couple of ways that this can arise in the middle of your trial, the procedure that's followed, and again, a few examples from the case law. So the legislation at issue here is section 644. This governs both the discharge of a juror, the possibility of replacing them before evidence is called. You can continue a criminal trial with it as few as 10 jurors if you end up discharging 2. And then if you fall below 10, you can, with the consent of the parties, convert your trial into a judge of law trial. The language in the discharge provision is very broad. It's other reasonable excuse or other reasonable cause. Again, we've been focusing really on bias and partiality today, so I'm going to continue doing that with 644. This could happen if, get a note that one of your jurors went home and like had a heart attack overnight or something. So there could be hardship issues as well that can come up. There's a new threshold, and the new threshold comes into play because something very important has happened since the conclusion of the challenge for cause procedure, and it is this. Does everybody see the very important change? So before being sworn in, these people were just people from all different walks of life.
You're so proud.
Great. I'm gonna do it one more time. Make sure everybody saw it.
Exploding star.
After being sworn, they're now judges.
Who's the person on the right?
Judge Dredd.
Oh.
So, and you'll hear once the jury's impaneled, the trial judge will explain this to them, that they are now judges of the Northwest Territories Supreme Court. And they sit in many respects on an equal footing with the trial judge. And so the reasonable apprehension of bias threshold, which comes from a case called Committee for Justice, and it's the same threshold you apply to a trial judge. That is the threshold that now applies to the jurors. And that is a real possibility that a reasonable person, properly informed and viewing the circumstances realistically and practically, could conclude that the decision maker might well be prone to bias. The presumption of juror impartiality at this point is very strong. It is premised on the fact that they've gone through the screening process, that they've now sworn an oath, and that they are now strongly presumed to follow the instructions that they're going to be given by the trial judge. And that is really one of the key focuses in these discharge applications, is whether the source of bias in this case is strong enough that you cannot rely on an instruction to address it. So this in the case law arises in a few different scenarios. You can have what's called jury discord. It's easy to lose sight of the fact that the jurors are human beings, and in particular, once they've been sequestered for deliberations, you take 12 strangers and lock them in a very small room, and then force them to come to unanimous agreement on a very difficult and important decision. And so tempers can flare, and things can go very wrong in that room. A related issue is that you will sometimes get a note from the jury essentially suggesting that one of the jurors in their deliberations is relying on biased or partial reasoning. One of the classics is the "wait, I know that person" situation, which is that you've come into the courtroom at the start of the jury selection process. You have read out the names of all of the witnesses, but a juror doesn't recognize a name. But then when they see the person in the courtroom, it's like, oh, like that's my daughter's best friend's mom. And like Bob Johnson is like Bob from the arena. Okay. And then you get a note from the judge explaining that they've now recognized this person. And then, as I said, you can have these issues of an inability to continue for health reasons. That can be some kind of physical affliction, and it can also arise from emotional distress, although the emotional distress is sometimes a more difficult one to navigate. The BC Court of Appeal is here to assure you that this is all very simple, that the procedure is well established, that all you have to do is just apply the proper legal test and conduct an inquiry. So you can all relax and not worry about it at all. The procedure is actually not well established at all. And in fact, one of the things that the courts are very clear on is that there is no set procedure for this. Because these issues can arise in so many different contexts and so many different ways, what the courts have done is to set out certain principles that you want to follow, but then leave the specifics of the procedure to the trial judge to determine. So the 4 principles that have been outlined is that you have to be fair to the parties and to the members of the jury. The procedure should be open in the sense that the trial judge's inquiry should take place in open court on the record and in the presence of the accused and counsel. This is an important one because it is not at all unusual for a juror who, again, is a layperson, to ask to have a private conversation with the judge. And there were some older cases, starting in the 70s, 80s, 90s, where trial judges were willing to do that and take a juror back in the chambers and then have a conversation with them. It's a very dicey proposition. And it arguably infringes on the accused's right to be present for all parts of his trial. Whatever procedure you do follow, it has to enable the trial judge to determine the true nature of the internal problem faced by the jury and to resolve it. And in doing this, you have to preserve the integrity, confidentiality, and impartiality of the jury deliberation process. And again, that can be particularly difficult when you have allegations of bias or when you have these jury discord cases. So a few general observations that I'll offer, having gone through this several times in a recent trial. These issues will often be drawn to the judge's attention either via a note from a juror or an observation of a juror's behavior or disposition by an officer of the court. That could be a sheriff, it could be counsel, it might even be somebody in the gallery who draws it to the attention of counsel. The trial judge, as I said, has significant discretion in deciding how to conduct the inquiry. The big issue that will come up on appeal is that whatever process they employ, it has to allow the trial judge to obtain the information necessary to exercise their discretion. So the 2 things that you'll see in the case law are, first of all, that the trial judge has a significant amount of discretion, but that exercise of discretion has to be based on like an appropriate, complete record. If you do undertake this inquiry, typically the jury is going to be excused. You'll do your best in a lot of cases to isolate the juror in question from the rest of the jury. So when it happened in the previous case I had, the juror was so they had already been sequestered. The juror was taken out of the jury room and given an office to sit in judges' chambers, while the judge and the accused and counsel sort of figured out what to do. And then the juror, who is sort of the subject of the inquiry, was brought in, and they can be questioned by the trial judge. Here, it's always been accepted and strongly stated that the questioning should be done by the trial judge. And you can obviously imagine the discomfort if, in particular, one counsel more than the other is, given the task of like cross-examining a juror and getting into this adversarial relationship with the juror, and then the challenge fails and the juror goes back in the jury room. The juror is not put under oath for this process. They are, as we've seen, a judge of the court. They've already taken an oath to follow instructions. And for the same reason, they are not cross-examined on whatever answers they give. There can be situations where you call other witnesses on the inquiry. Those witnesses are just normal witnesses. They can be put under oath and they can be cross-examined.
What if one juror is making allegations against the juror?
That's a great question. There's one example of it that we'll get to, but it's if it's not clear what you would do if you had two jurors who were just asymmetrically opposed, and if one juror said, juror number 4 said X, and then juror number 4 came into the courtroom and said, I never said that, and I don't believe that. Like it's not at all clear how you would resolve that. So a couple tips, and again, this is sort of coming indirectly out of the case law and just what I've seen myself recently. You'll notice when you're going over these cases that in almost every case, the juror will be asked if they've discussed the issue with the rest of the jury, because you want to ascertain the extent to which it may have contaminated the entire jury. You'll typically instruct that juror not to discuss the inquiry that you're conducting with the rest of the jury. And then in one of these kind of surreal moments of a trial, once you bring the rest of the jury in, whether a juror has been excluded or not, you'll instruct the rest of the jury not to speculate about what's been happening while 11 of them were excluded from the courtroom and one very obviously was not. And it's, just don't worry about it at all and put it out of your minds and don't speculate. And as I said, one of the real challenges in navigating these processes is not violating the deliberative secrecy of the jury. So a few examples of this from the case law. Martinez-Reynosa is a case where, so first a juror sends a note, and the trial judge's description of the note is that it spoke extensively about the conversations that they were having in the deliberations. And the trial judge says the note did not have a question, but it was clear the juror was using discriminatory thinking, speculating, and considering matters not in evidence. So what the trial judge did is sealed that note, did not share the note itself with counsel, but provided a summary to counsel. Despite the contents of that note, the juror was not discharged. Instead, they were given an instruction to rid their minds of their preconceived notions, biases, or stereotypes, not to speculate, and so on and so forth. They then get a second note, this time from the jury foreperson, indicating that the jury was at an impasse because one of their members was not working collaboratively, was speculating, and appeared not to understand the law. Again, the reaction to this from the court is to provide the jury with supplemental instructions and an exhortation. An exhortation is when the jury says they can't come to a verdict, and you call them into the courtroom and just like really underline for them how important it is that they come to a verdict. Please just try. Following that second note, the court receives 2 more notes. One from the foreperson and one from the aforementioned juror. The foreperson again says the jury is at an impasse because the juror, quote, was being combative, refusing to listen refusing to listen to their fellow jurors, speculating, twisting the evidence, not employing logic, and demonstrating a lack of partiality. The jury 4 persons note concluded with the question, how could we move forward? In the meantime, the juror had sent his own note, which again is described as a lengthy, detailed, and again revealed deliberations. Also clear that the juror was making findings for which there was no basis in the evidence, was speculating, misapprehending the law and the evidence, and believing evidence was being withheld from the jury. At this point, the trial judge concluded that this reflected an inability to deliberate and not just an inability to agree. That's an extremely important distinction in these cases. In that case, the sole juror, who seemed to be the cause of all the problems, was discharged, and the remaining 11 jurors were eventually able to reach a unanimous verdict a few hours later. I won't get into the Pringle decision, only to note that it's a similar situation, but the difference is that in that case, it resulted in a mistrial. And that's often going to be necessary in these cases, because if you think about it, like if it's going to often be very difficult to draw a line between cases where, you know, a juror is being disruptive and not following instructions versus these people just can't agree and things are getting heated. And if you have this kind of 11-to-1 scenario, and you're too casual about turfing the 1 and leaving the 11 to come to now what is a unanimous verdict, then really what you're doing is an end run around the requirement that a verdict be the unanimous verdict of your 12-member jury. And so that's the mischief that you have to be very, very cautious about in these types of cases. Durant was a sort of, hey, I recognize that person case. So Durant was a murder trial. The 2 victims were both sex workers. 2 hours into the evidence, the Crown learned that WK, who was the stepmother of one of the victims, knew one of the jurors. So this is a case where the individual comes to the Crown and says, actually, I do know that juror. She and the juror had patronized the same bar. She had other information about conversations that they had had. She said that the juror had actually offered her condolences when her stepdaughter had died. And she had also been a vocal advocate on behalf of sex workers. And in particular, had been quite critical of the criminal justice system and the lack of supports for sex workers. So the judge then conducts an inquiry of the juror. The juror says that they did know a woman whose first name was W, but that they didn't know her last name. They acknowledged they had seen W at the courthouse. They said that they didn't recall expressing their condolences to W. And so that is an example of where you could end up with this credibility contest. They then bring WK in. WK, as I said, is a normal witness. They are put under oath. Both the parties in this case agreed that the jurors should be discharged, but the trial judge disagreed and declined to discharge them. The appeal was allowed. I will say that that's a rare outcome in appeals. Deference to the trial judge's decision is really one of the defining characteristics of this area of the law. The Court of Appeal explicitly distinguishes the 3 thresholds that we've been talking about today. So the close connection under consent excuses, the realistic potential for partiality that triggers a challenge for cause, and the reasonable apprehension of bias test that's applicable to a juror once sworn. They talk about the standard of review and state that the Court of Appeal will only intervene where a trial judge's decision is tainted by an error of law or principle, there is a misapprehension of material evidence, or it is a decision that is plainly unreasonable. As is often typical of the Court of Appeal for Ontario, they don't explicitly explain how they're applying that standard of review in the case, but they do overturn the decision and say that the trial judge failed to give appropriate consideration to the importance of the appearance of fairness in deciding the suitability of the juror to continue. And they did note the joint position of what they described as being very experienced counsel. So as I said, it's a quite unique or a quite unusual result at the appellate level. Cunningham comes out of BC. It involved, I believe there was a murder trial as well. These all seem to come out of murder trials. An Indigenous accused. The court adjourns on a Friday. The sheriff then informs the judge of a letter that they received from a juror. The juror reports that she had seen a van driven by what she described as a First Nations male outside of her home. This caused her some concern, and so she had her neighbor pick up her daughter from the bus stop the next day. And then the neighbor found 2 bullet casings and what they believed to be gunpowder residue on the sidewalk. The juror said they had contacted the RCMP, but that the RCMP hadn't gotten back to her. And that the juror said that they wished to be excused from jury duty because of this, but that they would continue to serve if they were required to. By the Monday, the juror had spoken to the RCMP and she withdrew her request to be excused. So the judge conducted an inquiry with the juror. The judge found in this case that the incident in and of itself was not sufficient to raise a reasonable apprehension of bias. The judge's concern was that the juror had changed her mind about whether she wanted to be excused after she spoke to the RCMP. And reading between the lines, I think this occurred to the judge afterwards, like during the judge's deliberations, because it seems like that's not something the judge tried to explore during the inquiry. But that sort of troubled the judge enough that something could have been said between the juror and the, like, for example, if the RCMP member had tried to like reassure her that like it's a really important case and like if you were to cause a mistrial because of this, like that would be a real shame, that would obviously be extremely problematic. And so on that basis, the juror was discharged. The defense also wanted a mistrial. The mistrial application was dismissed, and this decision was upheld on appeal. There's also this really interesting issue that's left hanging in this case, which is that the defense had made a pretty broad-ranging disclosure request, essentially for like the investigative file that came out of these interactions with the juror. And so notes and reports of any officers responding and things of that nature. That's not something that the Court of Appeal explicitly weighed in on. All right, so as we've said, we've gone over 3 different sort of procedures, either for excluding a member from your jury or for discharging a juror once they've been impaneled. The first, the consent excuse, the legislation refers to personal interest, relationship, personal hardship, or other reasonable cause. You're dealing here with a relatively informal process. This is intended to deal with obvious cases where they're obvious enough that the consent of counsel can just be presumed. But I would suggest there's a possible controversy as to the proper scope of this and how it relates to the challenge for cause procedure. The statutory language for challenge for cause is that the juror is not impartial. In order to trigger the challenge for cause procedure, you have to establish a reasonable possibility or realistic potential of bias. That can be found based on evidence. It may be that the court can take judicial notice, and you can also draw common sense inferences. The purpose of the questions is to screen out jurors who are partial. And again, that's not the attitudinal partiality. It's not about outing a person for holding certain beliefs. It's to screen a person who can't set aside those beliefs and decide the case impartially. And in Schuin, the court says that one of the roles that it serves and one of the ways that you do this is that by putting these instructions and questions to the jurors, you encourage them to undertake the kind of introspection about their own biases, which is necessary in order to decide a case impartially. Once you've hit the threshold to engage the inquiry, you'll exclude a juror if that reasonable apprehension of bias standard, and again, it's the same community for justice standard, is met. Although we don't really know how appellate courts are going to the kind of standard of review that they're going to appeal to trial judges' reasons for excluding or not excluding potential jurors. And finally, you have the discharge of a juror. The statutory language in 644 is that the juror should not, by reason of illness or other reasonable cause, continue to act. The standard here is the Committee for Justice Reasonable Apprehension of Bias standard. The juror can be questioned, but they are now judges of the Supreme Court. So the questioning is done only by the judge. The juror is not put under oath and the juror is not cross-examined. And when you have arrived at this point, you are now dealing with a very strong presumption of impartiality, to the extent that things that might have caused you to keep a person off of your jury will not trigger necessarily discharging them from your jury. So always better to deal with these cases at the front end if you can. So those are the three mechanisms for keeping people off of your jury.
Great graphics.
All right. Well,
I have
thanks.
a question.
Sure.
On the challenge for cause,
Mhm.
the questions that you've asked, like for the one case you had like 4 or 5 questions listed there.
Yep.
Is there discussion between counsel and the court about, you know, oh, if they answer yes to these 3, they're off, or, you know, like what? Is that just purely left in the hands? Like, okay, we're gonna decide what the questions are. I'm not gonna let you know at all what my thoughts are gonna be on the answers.
I don't think it's the kind of thing that you can decide in advance.
Hmm.
Because you have to do this kind of like contextual balance of probabilities analysis. And you know, there are instances where, like, depending on the juror's answer, the judge might decide to probe a little bit further.
Yes.
And so I don't think you can kind of just sort of map it out where it's like, like
Just
three yeses or more and you're out, and 2 or less and you're in. So yeah, like for sure you're gonna do your best to map out how the process is gonna unfold, but I don't think that you could predetermine the outcome for any individual juror.
And in circumstances in the past, particularly, challenge for cause is a little different, but for excuse of juries, of jurors, which kind of have some overlap there. In the past, in my experience, people like once that conversation happens, you then excuse the juror. And then there's a discussion between counsel as to what to do or not to do, and then you bring the person back in and make the decision. Is that the same process for challenge for cause, or is that all done in front of the juror?
So the first difference would be,
the juror has done it all.
Yeah, so the first difference would be like in my experience, the consent excuse is done in front of everybody, right? And like people will come up and say like, I have a ticket to go to Vancouver tomorrow, and the judge will be like, all right, fine. So the first difference is that and it's actually, I was thinking about it when I was going through this in terms of like, how would we actually do it locally, right? Because like we'll do jury selection at like the Nova, and we have like 500 people in this giant boardroom. And that's also where all the recording equipment is, and it's where all the AV equipment is. So I think if you were going to do a challenge for cause like this, like you would have to talk through the logistics of it, because you're going to need another room, and you're going to need to bring them in individually.
Yeah.
I haven't seen anything like kind of determinative about whether you like bounce the potential juror out. If it were me, I would want to. Because again, you could get into this very awkward situation where one party might be saying like, well, this guy is plainly racist and we shouldn't let him on the jury. And then the judge decides like, actually, I think this person can set aside any biases that they have. And so to have been the lawyer who is accusing the juror of racism, and now the juror is now on the panel is like a very awkward situation to be in. So again, I can't say that I've seen anything definitive in the case law. Were it me, I would want to bring each juror in, ask them the questions, kick them out, bring them in, advise them of the result, and like either you're on the jury or you can go home now. And yeah, the logistics of it would be, I mean, I haven't seen it done, and it would be challenging, to say the least. Yeah.
No pun intended.
Hello.
Really, you were speaking about the questions to be asked of potential jurors and concerns about their privacy. Our local practice, when we're asking those preliminary questions, like is there any answer about the jury? I have seen follow-up questions to jurors who say, I've been affected by this particular offense as I reported. Like, there's questions about that in the presence of many other people. Should we be cautious about that or raise objections to those kinds of questions being asked in the presence of many other people?
I think it's very challenging. I have candidly, like, one of the things that was kind of an eye-opener for me when I was doing some of the research for this, I have seen jurors go up to the microphone and say, like, I have something that I don't want to say in front of everybody, I'd like to tell you. And I've had the judge like invite them up and just ask them to tell the judge.
Yeah.
And then the judge will go, okay. And then the judge will just say something very summary, like, you know, counsel, I'm satisfied that there's a significant hardship for this juror, so I'm going to excuse them. It's a dicey proposition. I will say that I was going to put in the presentation, but there is a case, there was a Supreme Court case that tried to distinguish between, I forgot the phrasing, but it's something like the juror, the accused's like critical interests versus non-critical interests. And I think tried to kind of like suggest that there was an opening for the judge to do that kind of thing. But I'd be very shy about it. And it's also one of these things where like, you just have to really hope that the judge has the experience and the tact to kind of navigate this, right? And so like, if somebody says like, I have like, you know, I have experience with personal violence, with sexual violence, that will make it very difficult for me to hear evidence. Like, you really hope that the judge is going to have the sense not to be like, well, real. And yeah, whether there was a, you know, whether there's a point at which I was, you know, willing to just lean in and be like, I think we've established enough and this juror should be excused for hardship, like maybe. But yeah, it could for sure get, it could be a very difficult thing to navigate. And again, it's one of these scenarios where it's like you are sitting up there in front of like A, it's a room full of 500 people, and B, 12 of those people are going to be the jury. And like, that's always like, there's a lot of pressure on counsel that like, you don't really think about until you're in that chair and you're being called upon to make like these split-second decisions about whether this is or is not an accepting juror.
What about asking to include a comment at the judge's introduction to the pool or the panel, potential jurors, like if you have something that's exceptionally personal, you can advise that, and we'll decide how to proceed from there. Just so someone doesn't feel like they need to get up and they just out of nowhere can convey very personal information.
Yeah, I mean, just actually now kind of thinking on my feet, you know, you could invite people that like if they want to write it down, that the note will be shared with the judge and the lawyers, but not read about in the courtroom. You know, it would create a sufficient record of proceedings, and it would respect the accused rights. You know, that might be limited to deal with it as well too.